Chhattisgarh has passed a new anti-conversion law, marking one of the strictest legal frameworks on religious conversion in India. On 19 March 2026, the State Assembly cleared the Freedom of Religion Bill 2026. The legislation replaces a law that dates back to 1968, when Chhattisgarh was still part of Madhya Pradesh. The bill is currently awaiting the governor's assent. The new law prohibits religious conversions carried out through force, fraud, allurement, undue influence, misrepresentation, or marriage. It also introduces provisions related to online or digital conversions, expanding the scope beyond earlier laws. One of the key provisions requires individuals to give a 60-day prior notice to district authorities before undergoing a religious conversion. This allows local to review the circumstances surrounding the conversion. Authorities have the power to intervene, and cases under the law will be tried in designated special courts. The law prescribes strict penalties. For general violations, the punishment ranges from 7 to 10 years of imprisonment, along with a minimum fine of 5 lakh rupees. If the person being converted falls under specified categories, including minors, women, individuals with mental illness, or members of scheduled castes, scheduled tribes, or other backward classes, the punishment increases to 10 to 20 years with a fine of 10 lakh rupees. The law also defines mass conversion as involving 2 or more individuals. In such cases, the penalty ranges from 10 years to life imprisonment, along with a fine that can go up to 25 lakh rupees. Repeat offences can lead to life imprisonment. This development comes amid a broader trend of similar legislation in multiple states. Recently, Maharashtra passed its own version of a freedom of religion law with comparable provisions, though the penalties differ. At the national level, the Supreme Court of India is currently hearing petitions that challenge anti-conversion laws in various states. These petitions raise questions about the interpretation of Article 25 of the Constitution, which guarantees the right to freely profess, practice, and propagate religion. The background of such laws in India dates back several decades. The first anti-conversion law was enacted in Odisha in 1967, followed by Madhya Pradesh in 1968. Chhattisgarh retained a similar legal framework after becoming a separate state in 2000, and has now updated it with stricter provisions. In recent years, several states have revised or introduced new laws addressing religious conversion. Some of these laws have included provisions related to marriage, prior declaration requirements, and enhanced penalties. The issue has also been part of ongoing political and legal discussions. In 2025, a proposal in Madhya Pradesh suggested introducing the death penalty for forced conversions, though it has not been enacted into law. Cases linked to anti-conversion laws have also been reported in different states. These often involve police investigations, legal proceedings, and judicial review. Observers note that outcomes vary, and some cases remain pending for extended periods. The implementation of such laws, their legal validity, and their impact continue to be subjects of examination in courts as well as public discourse. As the Chhattisgarh bill awaits final approval, it adds to the evolving legal landscape surrounding religious conversion in India.